Sorry about that. Please hold on for us. We need to switch our systems and get the best network we can at this time. Thank you.
All right. All right. Good afternoon, members of the bar. You're welcome to today's proceedings. We are going to take the judgments. We have 5 judgments in quick succession. I'm not going to read the whole judgment. I'll talk to the judgment, and when you get the judgment, you will read the entire judgment.
As a copy.
Registrar, call up number 1.
As the court pleases. Judgment in appeal number CA/ABJ/CR/445C/2020 between Idris Tijani and the state. My lord, parties are absent.
Of the contest. With the greatest respect to my noble lord, A.O. Ige, with me is my learned friend, Onu Daniel. Our humble appearance is for the appellant. May it please my lord.
Yes, who's on the other side?
Well, I'm aware the DPP of Kogi on the other side, but it's not on the platform.
The respondents in this appeal were served.
Yes. When were they served?
My lord, the respondent was served on the 29th of May, 2020. They were served through phone calls, text messages, emails, and WhatsApp.
Phone call on?
Text messages.
Phone call on what number?
0706.
Yes.
53.
53.
Yes, my lord.
Yes.
56.
5356.
Yes, my lord. Then another 691.
691.
Yes, my lord.
Received by? Who received the phone call?
My lord, is H.O. Abdullahi, DPP, Kogi State.
The name again?
H.O. Abdullahi, Esquire, DPP, Kogi State.
Okay, via phone call, text message to SMS to the same number?
Yes, my lord.
And email.
Email.
Let me show.
The appeal was taken by a panel that consisted of my Lord Honorable Justice M.A. Edmen. He presided. I was in the panel. Honorable Justice E.O. Williams Daudu was in the panel. We took the appeal, held conference, took a decision on the appeal. I wrote the lead judgment and I'll go ahead to deliver it. The appeal is against the judgment of the High Court of Kogi State in case number AHC/16/2019, which was delivered by A.M. Awulu J on the 29th day of April 2020. The appellant was charged and convicted on 2 counts charged for the offense of criminal conspiracy contrary to section 97 subsection 1 of the Penal Code and offense of culpable homicide punishable with death contrary to section 221 subsection A of the Penal Code. The trial court convicted the appellant who was the accused, and being dissatisfied, he has appealed to this court. The appeal was argued 4 hours after the relevant processes were filed by the counsel on both sides. Mr. A.O.Ige, for the appellant, in his brief of argument, raised 2 issues for the determination of the appeal, while for the respondent, Mr. A.W. Zachary raised the sole issue for the determination of the appeal. I considered the issues raised by both parties and I'm of the opinion that the sole issue that was distilled by the respondent will determine this appeal. And so this appeal has been determined on that sole issue. I have summarized in detail the submissions of counsel for both sides. And in my resolution, I defined what a culpable homicide is under the Penal Code. And I considered the evidence of both parties. The case is that One Mr. Shekuru had a misunderstanding with the wife, and according to him, he called on the father-in-law to intervene, but he did not. Council, can you hear me? They've lost me.
I can hear you, my Lord.
You can hear me, okay.
Yes, my Lord.
So Mr. Shekuru had a misunderstanding with the wife and called on the father-in-law, reported to him to intervene, but he did not. And quarrel ensued, according to the evidence of the father-in-law, who was the DW2, whereupon the complainant, Mr. Shekuru, invited his siblings and others to join him in the fight. And in the course of the fight, the deceased, who is the elder brother of Mr. Shekuru, was hit on his head and he passed on. He fainted and was taken to the hospital, where he died after 3 days. From Mr. Shekuru's evidence and the evidence that was laid before the court, I considered alongside the law, and I came to the conclusion that the prosecution did not prove that it was the appellant hearing that hit the deceased with the stick that eventually led to his death. The evidence of DW2, the father of the deceased, was not cross-examined. It was not cross-examined, which in law means that the facts stated has been accepted as the truth of the matter. And so I based on his evidence, in line with the position of the law, to come to this conclusion. And on the issue of criminal conspiracy, I also, based on the law and the evidence before me, came to the conclusion that the prosecution failed to prove that there was an agreement between the appellant and his siblings to hit the deceased. So in all, I held that the trial court was wrong in convicting and sentencing the accused for the 2 counts charge. So consequently, I hold that appeal meritorious and the same is consequentially allowed. I set aside the conviction and sentence of the trial court delivered on the 29th day of April 2020 by A.N. Woluje in case number FC/16/2019. I discharge and acquit the appellant on the offenses of culpable homicide and criminal conspiracy. Before now, Honorable Justice Adumen read this judgment, and he also agrees with the decision that the appeal is meritorious. He also has set aside, quashed the conviction and sentence of the trial courts, of the appellant by the trial courts. Also, Honorable Justice Dawood Williams has quashed the conviction and sentence of the appellant by the trial courts. This is the judgment of the court.
As the court pleases.
As the
court pleases.
We are most grateful, my Lord. Thank you, my Lord. My Lord, we are grateful for the judgment.
My Lord, we are most
So we'll
grateful for
collect
the judgment.
the judgment and read thereafter.
As the court pleases.
Yes, registrar, call the order.
As the court pleases. Judgment in appeal number CA/ABJ/CR/6. Ms. Nima, please mute your microphone. Sorry, my Lord, we were interrupted because of the echo that came in earlier.
Hello, my lord. Hello. The next one is appeal number CA/ABJ/CR/634/2020 between Alexander Micah Penman against Federal Republic of Nigeria.
Yes.
Yes, my lord. Parties are absent.
Mr. Francis. Appearances.
Parties are absent, my lord, but they were duly served.
Yes, appearance.
With utmost, my lord, I do not know if the appellant is available. I am for the respondent, my lord.
Yes, there's somebody entered wrote down his name on the council's list. J.M. Matthew, is it not?
My lord, in that case, let me wait for the appellant to announce his appearance.
Yes, J.M. Matthew. You are not on the screen.
My lord, in that case, can I go ahead and announce my appearance? My name is Osuobeni Ekoi Akponimisian, my lord. Akponimisian, as it appears on the record, my lord. I'm a principal legal officer with the ICPC.
Hold on.
Akponimisian, my lord.
Okay.
I'm a principal legal officer with the ICPC.
Okay.
Principal legal officer with the ICPC. I humbly appear for the respondent. Most grateful, my lord.
Yes. The appeal
Yes,
was taken by a panel consisted of myself. I presided. Honorable Justice S.J. Ada was in the panel, and Honorable Justice E.O. Williams Daudu was in the panel. I presided. I wrote the lead judgment after our conference, and I'll go ahead to deliver same. Like I said earlier, I'll talk to the judgment, and when you get the judgment, you will read it in details. It's an appeal against the judgment of the High Court of Federal Capital Territory sitting at Abu, which was delivered by Ulukademi J in charge number FCT/HC/CR/321/17, wherein the electoral judge convicted the appellant on 3 counts, on counts 3 and 5 of the 5 counts charged filed by the respondent. Being dissatisfied, the appellant brought this appeal. I produced the counts, particularly counts 3 and 5, under which the appellant was convicted. There were 2 accused persons at the trial court. The first accused, the other accused was charged under the other counts. There were 5 counts.
Recording in progress.
But he was discharged and acquitted, and the appellant was convicted on the 3 counts charge. He had to, they charge the count 2 of the charge read that you, Mohammed Musa, count 3, which pertains to this appellant, reads that you, Alexander Micah Berman, sometime in December 2014 or thereabout in Abuja, while being in the employment of the Federal Ministry of Works, Abuja, as Assistant Director, Special Duties Department and Chairman, Anti-Corruption and Transparency Unit, ACTU, of the Federal Ministry of Works, Abuja knowingly furnished false return of retirement claims in respect of the total sum of 4.5 million out of the 5 million naira approved by the Permanent Secretary. By the Permanent Secretary, Federal Ministry of Works, Abuja, and paid into personal diamond account number this provided for the observance of the International Anti-Corruption Day on the 9th of December 2011 by the Anti-Corruption and Transparency Unit of the Ministry and its Parastate House, that the said sum was expended for that purpose when you knew it was not, and you thereby committed an offense contrary to and punishable under Section 16 of the Corrupt Practices and Other Related Offenses Act 2000. And count 5 reads that you, Alexander Micah Berman, male, sometime in March 2015 or thereabout in Abuja, while being in the employment of the Federal Ministry of Works, Abuja, used for your position as an Assistant Director and Chairman, Anti-Corruption Transparency Unit of the Ministry of Works, Abuja, to confer corrupt advantage upon yourself when you received and expended for your personal use the sum of 400,000 naira, being contribution from the Office of the Surveyor General of the Federation to support the observance of the International Anti-Corruption Day on the 9th of December 2014 by the Anti-Corruption and Transparency Unit of the Ministry and its parastatals, and you thereby committed an offense contrary to and punishable under Section 19 of the Corrupt Practices and Other Related Offenses Act 2000. Like I said, the appellant was convicted by the trial court, and in dissatisfaction, he has brought this appeal. The appellant, who was represented by Chief Olushola Oke, SAN, and who appeared with SM Onekutu and Vincent Adudu in their brief of argument, distilled 4 issues for determination. Mr. Akboni Misen, I hope I didn't murder your name.
No, my Lord, my Lord is allowed.
I tried.
No, my Lord tried. My Lord, it is a very long name. And when people pronounce it, I normally give them accolades. Thank you, my Lord.
So, for the respondents, we distilled 2 issues for determination. I consider the issues, and I'm inclined to adopt the 4 issues formulated by the appellant for the determination of the appeal, being the initiator of the appeal. On issue 1, which is whether count 3 of the amended charge under which the appellant was tried, convicted, and sentenced disclosed against the appellant the offense under Section 16 of the Corrupt Practices and Other Related Offenses Act. I summarize the arguments of both parties, and in my resolution, I resolved the issue in favor of the respondent. And on count 2, which is for the whether the respondent proved the offense of knowingly furnishing false returns of retirement claims under Section 16 of the Corrupt Practices and Other Related Offenses Act 2000, as alleged in count 3 of the amended count charge against the appellant beyond reasonable doubt. Again, summarize the issue. I summarize the arguments of both counsel and consider the issue with the arguments and the position of the law. And now I resolved the issue in favor of the respondent. And on count 3, whether the decision of the trial court convicting the appellant for conferring corrupt advantage on himself contrary to Section 19 of the Corrupt Practices and Other Related Offenses Act 2000 as laid down in count 5 of the amended charge was not perverse and thus occasioned the miscarriage of justice. Again, I summarized the submissions of counsel and the resolution. I held that there was no miscarriage of justice, so I also resolved in favor of the respondent.
As a court, please.
And on issue 4, whether the trial court was not in grave error which has occasioned a miscarriage of justice when it sentenced the appellant to a maximum punishment prescribed for the offenses charged having regards to section 416 sub 2 of sub 2D of the Administration of Criminal Justice Act 2015. I also summarized the argument of counsel, and in my resolution, I am of the opinion that the learned trial judge was wrong to have closed his eyes to section 416 subsection 2D of the Administration of Criminal Justice Act, even though it was not brought to his attention. So, being the law in operation, the trial court was supposed to take that into cognizance. And for the fact that the appellant is the first offender, he was supposed to, by virtue of that section of the act, not impose on him the maximum punishment. But I've looked at the law, the maximum punishment for each of those two counts, 3 and 5, 7 years respectively, 7 years respectively, 7 years for count 3, 7 years for count 5. And the trial court has said his hands were tied. I don't know why his hand was not tied in the other count that he imposed, he sentenced him to 5 years. So I looked at it and I said it was a miscarriage of justice. It was wrong. His decision to sentence him on count 3 for 7 years was per incuriam because they didn't look at the proper law. So I varied the sentence on count 3 to make his, since he had already given him count 5, 5 years for count 5, I also varied to the sentence to be for 5 years. So that is, to that extent, the appeal succeeded minimally to the extent that I varied the sentence on count 3 to 5 years. And I held that the sentences will run concurrently. Before now, Honorable Justice Ada read this judgment, and he's also of the opinion that the judgment of the trial court will stand, but varied on the issue of sentence.
As the court pleases.
Also,
The court pleases.
Honorable Justice E.O. Williams Daudu also varied the decision of the trial court sentencing the appellant with the first offender to 5 years imprisonment on count 3 of the charge. That's the judgment of the court.
As the court pleases.
As the court pleases.
As the court pleases.
My Lord, we are most grateful. We thank my Lord for the well-considered judgment. Mine is always that I have to pray for my Lord because it's a very opulent task. May God continue to give my Lord the energy and the protection through Jesus Christ our Lord. Most grateful.
Amen. So much. Thank you.
I can leave the meeting, my Lord.
You can.
Thank you, my Lord.
So the Mr. Matthew was not able to join us. Okay, Mr. J. Matthew.
Yes,
you are there now. I can see you. Yes,
yes, my Lord.
We saw
I
that
apologize, my Lord, for joining.
It
was network issue.
Yes, it's okay. Okay.
And we are grateful, my Lord, for the well-considered judgment.
I entered your appearance. I wanted to be sure whether you were able to make it.
Yes, my Lord. Okay. I made it. We are grateful.
Yes, call number 3.
As the court pleases. Judgment in appeal number CA/A/519/2016 between Mrs. Jumai Zion and Nigeria Railway Corporation. Parties are absent, my lord.
Appearances.
With profound respect to my lord, my name is J.G. Taidi.
Yes.
My humble appearance is for the appellant.
Yes.
I'm much obliged.
Who's on the other side? Yes. Who's on the other side?
Mr. Aidi, I can see him online.
Is there representation for him? Is online? He didn't sign the council list.
He came in late. I saw him a while ago, but now he's gone off. He's gone off. Probably having
yes, announce the appearance.
Unmute yourself, please, and announce your appearance, sir.
With profound respect, my lord. Bola Niwa Elijah ID, my lord. My humble appearance is for the respondent. And appearing with me, my lord, is S. Oguche. We are grateful, my lord.
Bola Niwa Elijah.
Elijah ID, my lord.
Elijah ID.
ID.
Okay. With
AID.
Say appearing with who?
Appearing with S.
Yes,
Oguche. S. Oguche. S. Oguche. Oguche is O-G-U-C-H-E, my lord.
Okay. For respondents.
For the respondent, my lord.
Mr. Post, please mute your microphone. Every other person, please mute your microphone until you're asked to speak. Thank you very much.
Yes, the judgment was, the appeal was taken by panel, presided by Honorable Justice M. Edmund. I was in the panel. Honorable Justice E.O. Williams Daudu was in the panel. We held conference, agreed on the decision. I wrote to the late judgment. I'll go ahead to deliver it. The appeal is against the ruling of the High Court of Niger State in Minna, delivered on the 17th day of March 2016, wherein the learned trial judge Maria Zanda Zukugi J. declined jurisdiction and held as follows. The alleged action which gave rise to the cause of action here falls within the powers and function of Nigeria Railways Corporation and exception to the rule will not avail the plaintiff here. Furthermore, the battery is low. This battery is low now. Furthermore, as submitted in the appellant's reply on points of law, Section 83, sub 2 of the Nigerian Railways Corporation Act, Cap 129, Laws of the Federation of Nigeria 2004, provides that no suit shall be commenced against the corporation until 3 months after written notice of intention to commence the same shall have been served upon the corporation by intending plaintiff or his agent, and such notice shall clearly and explicitly state the course of action, particulars of the claim, the name and place of abode of intending plaintiff, and the relief which he claims. That notice the plaintiff did not serve. For all reasons stated above, the court lacks the jurisdiction to entertain this matter, and I consequently strike out the same. Dissatisfied with this ruling of the trial court captured by the excerpts I have quoted, the appellant brought this appeal. Mr. Tidy, who represented the appellant in his brief of argument, raised 2 issues for determination, while Mr. ID also raised 2 issues for determination. Upon careful inspection of the 2 issues raised by the appellant and the respondent respectively, I have the view that the 2 issues raised by the respondent, which emanate from the grounds of appeal, will suffice for the determination of the appeal. I shall therefore determine this appeal on the referred 2 issues. The fact of the case is that the appellant's husband was run across by a train that was coming from Lagos to Minna. She said that there was a traffic, and so they were on the husband who was driving was exactly on the rail. The Nigerian Railway did not put their staff to warn people against the oncoming. Hold on for a minute, I'll come back to you. The battery is low. Okay. So the Nigerian Railway did not warn road users that there was an oncoming train from Lagos to Minna. And so neither was there a barrier to stop people from being on the rail. So while there was traffic, she said she got out to go and check what was wrong, and then
Hi, so we are very sorry about the inconsistencies. Please bear with us. We are having some technical challenges here. Thank you.
crushed him. She brought this action against Nigerian Railway for negligence and failure to observe duty of care to road users. The major issue is that as can be seen in the first issue, whether the learned trial judge erred in law when he held that the claim of the plaintiff before it was started bad. An objection was raised that the claim was started bad, the same not having been brought within 12 months as provided for by Section 83 of the Railway Act. And the argument of the respondent was that no, by Section 2 of the Public Officers Act, the negligence and failure of the respondent to provide duty of care is an exception to the rule. And, the trial court considered it and said no, that the appellant's case was started bad, as I read earlier, because there was that the trial court had no jurisdiction to hear the appeal, to hear the action, because there was no 3 months notice of intention to bring an action as provided by subsection 2 of Section 83. And argument is that the trial court was wrong to say that the action was started bad. So I have looked at Section 2 of the Public Officers Protection Law and Section 83, subsection 1 of the Nigerian Railway Corporation Act. And I came to the conclusion that the trial court was right in holding that the action was started bad, the same not having been brought within the time limit as provided by Section 83 of subsection 1 of the Nigerian Railway Corporation. The fact that it was negligent or that they didn't observe duty of care did not take the action outside Section 83, because it's very clear in Section 83 and even Section 2, subsection A of the Public Officers Protection Act, that even in cases of negligence, the action still has to be brought within the prescribed time. So I resolve the first issue in favor of the respondent against the appellant. Section 2, considering the issue is considering the fact that the respondent's preliminary objection was predicated on a single ground, whether the trial court was right to so much to raise the issue of 3 months pre-action notice without invited parties to address the court on it. I considered the agreements, and in my resolution, I considered Section 83 of the Civil Procedure, of the Nigerian Railway Act and other relevant authorities. And I came to the conclusion that the trial court, the respondents in answer did not raise any new issue. I did not say any new issue raised. The whole argument centered on whether or not the suit is started bad by Section 83, subsection 2 of the Nigerian Railway Corporation Act. So, in my view, there was no new issue raised. And what the trial court did was look at the subsection 2 of the Act to come to the conclusion that yes, even when the action is brought within the 12 months, a pre-action notice is provided for. And just consider that very section in full in coming to its conclusion. So in conclusion, I say consequently, I hold that the fact that the trial court reproduced section 83 subsection 2 of the Nigerian Railway Corporation Act cap 129 while considering the respondent's reply on points of law does not amount to any miscarriage of justice. This is because the trial court relied on section 83 subsection 1 of the Nigerian Railway Corporation Act Supra in declining jurisdiction to entertain the matter, and not solely on section 83 subsection 2 of the Nigerian Railway Corporation Act cap 129. I disagree with the arguments of the appellant on this issue. I hold that the trial court did not raise issues suo motu without inviting the parties, particularly the appellant, to address it. Therefore, the trial court did not violate the appellant's right to fair hearing. I resolve this issue against the appellant and in favor of the respondent. Having resolved the two issues in favor of the respondent and against the appellant, I hold that the appeal lacks merit and the same is hereby dismissed. I affirm the ruling of the High Court of Niger State delivered by Maria Zander Zukugi J on 17th March 2016. I make no others to cost. Before now, Honorable Justice Adume read this judgment. He is also of the opinion that the appeal lacks merit. He also dismisses the appeal and advised by the others to cost. Also, Honorable Justice Williams Daudu, before now read this judgment. She is in agreement with the judgment just pronounced, and that's the judgment of the court.
As the court pleases.
As the court pleases. We thank your lordships for the well-considered judgment. We're both grateful.
As the court pleases, my lord.
My lord, we're equally grateful for the well-considered judgment.
Call number 4.
Pleases. Judgment in appeal number CA/A/978/2019 between Picamp Investments Limited and Director General Industrial Training Fund and 3 others. Parties are absent, my lord.
Appearances?
Yes, my lord. May it please my noble lord, I am Marvel Akboibo, DIG retired. And with me, my lord, and my learned colleagues, Olakunle Lawar, and Fred Ajefu Obago.
You're appearing with?
I'm appearing with my two learned colleagues, my Lord. Olakunle Lawal and Fred Ajefu Obagu. My Lord, our humble appearance.
Olakunle Lawal and who?
Fred Ajefu Obagu. Fred.
Fred.
Obagu is spelled O-B-A-G-W-U.
Fred who? Before the...
Ajefu.
What's the middle name?
Ajefu Obagu.
Fred A.
Obagu, yes, my Lord. Fred A.
Yes.
Obagu.
It costs too much. Please spell the last name.
The last name is O-B-A-G-W-U, my Lord.
Okay.
My Lord, our humble appearance is for the appellants in this matter.
Yes. Please for the respondents. Registrar. Respondent is online. And it is signed, the respondent is signed on the cancel list. Yes, what's the name?
My Lord, can you hear me? Yes, my Lord, the response was not online when we were taking the appearances. So he later on sent a message to us telling us that he's having difficulty connecting. But he's online now. I don't know why he's not talking. John Godwin, Esquire.
John Godwin.
Yes, my Lord.
For the respondents.
Yes, my Lord.
Yes, the appeal was taken by a panel of Honorable Justice M.A.A. Adumen, who presided. I was in the panel. Honorable Justice E.O. Williams-Daudu was in the panel. We held conference, agreed on the decision, I wrote the lead judgment and I'll go ahead to deliver it. The appeal is against the decision of the High Court of Federal Capital Territory delivered by Jude O. KKJ of blessed memory on the 30th day of May 2019 in suit number FCT/XT/CV/1069/2017, wherein the learned trial judge dismissed all the claims of the appellant. The appellant initiated her suit at the trial court under the undefended list via a writ dated on the 1st day of March 2017 against the respondent seeking for the following reliefs: a declaration that the plaintiff is entitled to the sum of 99.530 million naira only, being the plaintiff's agreed professional fees for the purchase of the property known as Plot 144 of Bakron Avenue, Ikeja, Lagos. An order directing and mandating the defendants jointly and severally to immediately pay to the plaintiff the sum of 99.530 million naira only, being the plaintiff's professional fees for the purchase of the property known as Plot 144 Oba Akran Avenue, Ikeja, Lagos. 9% interest on the said sum of 99.530 million from the date of judgment, from the date judgment is delivered to the date when judgment sum will be finally liquidated. Cost of action assessed at 5 million naira only. The fact is that the appellant sometime in 2014 offered to sell the plot 144 at 1.2 million naira. And then second respondent made a counter offer to buy at 995,300,000 naira. Eventually, the two parties agreed, and Exhibit G was made, which spelled out the purchase price and other fees that will be due. At the trial court, the judgment was against the appellant, that all that was due him had been paid. That's including the legal fees and agency fee. And so this appeal was brought in dissatisfaction of the judgment of the trial court. When the appeal was taken, the learned counsel for the appellant, DIG Maverick Lee Apoido, adopted his brief of argument wherein he raised the 3 issues for determination. Also, John Godwin adopted his brief wherein he distilled 2 issues for determination. Upon calm examination of the 3 issues raised by the appellant and the 2 issues raised by the respondents, I adopt the 3 issues raised by the appellant for the determination of this appeal. The first issue is whether the trial court was right in its interpretation and application and variation of Exhibit G. Like I said, Exhibit G was as a result of the counter offer. I have summarized the arguments of counsel on both sides, and in resolving issue 1, I have set out Exhibit G for ease of understanding. And that exhibit spelled out the next purchase price, 5% VAT, 10% WHT, 5% legal fee, and 5% agency fee. There was no argument or dispute that the sum of 995,300,000, which is spelled out as next purchase price, had been paid. But the argument of the respondent is that that now includes the 5% legal fee and 5% agent fee. The argument being that they had invited the managing director of the appellant and agreed with them that 995,300 will be for both the purchase price, 5% legal fee, and 5% agency fee. Let me note that the managing director was not named, and outside the evidence of the respondents, there is nothing before the court to show that there was any intention to orally vary Exhibit G. I've noted the general principle of law on agreement of parties, and that when parties enter into a contract, it cannot be varied unless there is anything to show to the contrary that they intended to go outside the agreement they have reached. So herein is the G, which is the agreement of both parties, has not been shown to have been varied by the parties. Even the minutes of the meeting supposedly held with the managing director where the variation was agreed on is not before the court. So I came to the conclusion that it's a settled principle of law that where contract is in writing, any agreement which seeks to vary the original agreement must itself be in writing, given authority to that effect. However, the only exception to the above rule is where there is tangible proof before the court to show that there is an oral agreement to the contrary. There is nothing before this court to show that there was a subsequent agreement to vary the content of Exhibit G, other than the oral testimony of the respondent's witnesses. Like I said, the minutes of the meeting allegedly held with the named managing director was not placed before the court to establish that there was further agreement, be it oral, after Exhibit G. Flowing from the related position of the law, which I have stated in this judgment, it is my view, and I so hold, that extensive evidence cannot be admitted to vary the content of Exhibit G. So I hold that the trial court was right in its interpretation of Exhibit G and resolved the issue in favor of the appellant. For the submissions on issues 2 and 3, which were taken together, I've also resolved them together, which is whether the appellant did not discharge the burden of proof placed on it, and whether the trial court misconceived or misapprehended the case of the appellant, which has occasioned a miscarriage of justice. I have also summarized the argument of both counsel in these two issues. And in resolving the issues, I came to the conclusion that I agree with the decision of the learned trial judge. I came to the conclusion, let me take it from here. The third contract agreement, in my view, as I had earlier held in this judgment is explicit on the figures and needs no further interpretation. Failure of the respondent to establish that there is an existing oral agreement which altered the existing contract leaves the court to speculate. This court cannot speculate. The court only acts on empirical facts. So I refuse to yield to the beckon of the respondent's stance to speculate. I've given the authorities to that effect. For what I have said above, I disagree with the decision of the learned trial judge. Rather, I hold that the respondent is liable to pay the professional fees as contained in Exhibit G. Thus, the decision of the trial court occasioned a miscarriage of justice. I resolve this issue in favor of the appellant. Having resolved the two issues in favor of the appellant, I hold that this appeal is meritorious and the same is hereby allowed. The judgment of the High Court of Federal Capital Territory, Abuja, in suit number FCT/HC/CV/1069/2017, delivered on 30th day of May 2019, is hereby set aside. Consequently, I hereby order as follows: that the appellant is entitled to the sum of 99,530,000 naira only, being the appellant's agreed professional fees for the purchase of the property known as Plot 144 Obakoron Avenue, Ikeja, Lagos. 2, the respondents are directed and mandated jointly and severally to immediately pay to the appellant the sum of 99,530,000 naira only, being the appellant's agreed professional fees for the purchase of the property known as Plot 144 Obanakron Avenue, Ikeja, Lagos. That 9% interest on the set sum of 99.530 million naira be paid to the appellant from the date of the judgment of the trial court and until the judgment sum is fully liquidated. I make no order as to cost. Before now, Honorable Justice M.A. Adumen read his judgment. He is of the agreement that the appeal has merit. He abides by the orders made herein in this judgment. Also, Honorable Justice E.O. Williams Dauju read before now the judgment just delivered, and she is in agreement with the conclusion reached thereat, that the appeal has merit and abides by the orders made. This is the judgment of the court.
As the court pleases.
My Lord, we sincerely want to appreciate your noble Lord for this well-considered judgment. All we owe you is prayers for long life and more wisdom to dispense justice, just as you have done this afternoon. We are saying the Lord will bless you and keep you and preserve you and your family. And that is our prayer for you, my Lord. Thank you very much.
Amen.
Welcome, Pastor.
Call number 5.
As the court pleases. Judgment in appeal number CA/A/146/2019 between Peace Capital Markets Limited and John Ujam. Parties are absent, my lord.
My name is U.A. Ojiabo, O-J-I-A-B-O. Humbly
Come again. You didn't write it. Come again.
Very well, my lord. U.A. Ojiabo, O-J-I-A-B-O. for the appellant. May the
Oh,
court please.
that's how you pronounce your name, Ojiako.
Ojiabo. Abo.
Ojiabo.
Yes, my lord. Ojiabo.
All right.
May the court please. Very well, sir.
Okay. Yes.
With greatest humility, my lord. I am Amushin Namani Wanko.
Amushin Namani.
Wanko, my lord. Appearing with me is Kenneth Timber.
Namani Wanko.
Namani Wanko, my lord. It's a compound name.
Yes, okay.
My lord, the respondent is in court with me here.
With Kenneth
Timber, Timbe. My lord, the respondent is Mr. John Ojan is with us here.
So Mr. John Ojan did what?
He's with us here, my lord, the respondent.
He is in court.
Yes, my lord, he's
so
in court.
Why did he allow himself to be marked absent?
He came in late.
The appeal was taken by a panel consisting of Honorable Justice M.A. Adumen. I was in the panel. Honorable Justice E.O. Williams-Daudi was in the panel. We held conference, agreed on the decision. I wrote the lead judgment and I'll go ahead to deliver it. The appeal is against the judgment of the National Industrial Court delivered by O.Y. Anume J. on the 10th day of October 2018. The fact of the case as presented is that the respondent by complaint dated and filed the 13th day of June 2015 sues the appellant at the Abuja Judicial Division of the National Industrial Court of Nigeria for wrongful termination of his appointment. Set out the relief sought by the appellant. Sorry, the relief sought by the respondent, who was the plaintiff at the trial court. The appellant being dissatisfied has brought this appeal because the trial court entered judgment in favor of the respondent as follows. That is ordered to pay the sum of 504,000 naira to the claimant, while the claimant is to pay the sum of 50,000 naira to the defendant. The defendant is to deduct this sum from the sum the claimant is entitled to pay, to be paid by virtue of this judgment, and pay the balance, which is 454,000 naira to the claimant within 30 days from today, failing which the sum will begin to accrue interest at 10% per annum until it is fully paid off. Parties shall bear their cost. That was the judgment of the trial court. Dissatisfied with this judgment, Peace Capital Markets Limited brought this appeal. The appellant raised the 4 issues for determination, while the respondent raised the sole issue for determination. I have decided to determine the appeal based on the 4 issues raised by the appellant. On issue 1, which is whether an unsigned, untitled, and undated document has any evidential value in law. I summarized the argument of both counsel. It's a very short judgment, so I'll just go ahead and read the resolution of each of the issues. So in resolving issue 1, I said the issue which the court hearing is called upon to determine is whether an evidential value can be attached to Exhibit C 6A, being the appellant's handbook, which is unsigned, untitled, and undated. What is the evidential value? It is the weight which a court attaches to evidence. Evidential value is determined by admissibility. It is a general principle of law that unsigned and undated documents are invalid and has no evidential or probative value. See the case of Vishani against the Brahams and another, cited in 2015. This general rule, however, is not without exception. Thus, when certain situations exist, an unsigned document can be admissible. See the case of Ashakesem PLC and the Asharatu Mubasharu Investment Limited. Therein the Supreme Court said, the legal requirement of signature on a document is to determine the document's origin and authenticity with regard to its maker. So, where certain situations exist, an unsigned document could be admissible where oral evidence is presented to clarify the document and its authorship. In this case, the parties agreed that Exhibit L emanated from the appellant and rendered it admissible. Therefore, the Court of Appeal rightly found the document as admissible, or was admissible, unquote. In this case, from the record of appeal before this court, particularly pages 110 to 122 of the records, Exhibit C 6A is the new handbook of the appellant, which was given to the employees of the appellant, including the respondent's hearing through his email box by one Mr. Hysentese, who testified in his evidence in chief that he is the manager of the appellant as contained at page 147 of the record. It is the contention of the appellant hearing that the said Exhibit C6A is not admissible because the same is not dated or titled. Furthermore, it is not the argument of the appellant that Exhibit C6A did not emanate from Mr. Hyacinth Eze, who is obviously a manager of the appellant, as same was already admitted in evidence and needs no further proof. It is also not the argument of the appellant that Exhibit C6A is this new handbook that was sent to the respondent. The only area of disagreement between the parties is on its admissibility, since it is not titled, signed, and dated by the said appellant, who is the maker of the document and who it undeniably emanated from. The respondent's hearing, in a further proof of the admissibility of Exhibit C6A, tendered Exhibits C10A and C10B as contained at pages 128 to 129 of the records, which are the evidence that the appellant has been applying Exhibit C6A. The appellant, in rebuttal of this on the order G3, as contained at pages 132 to 134 of the records, which are evidence to the effect that the appellant's chairman queried his manager for using Exhibit C6A to run the company. Going by the above, the obvious fact is that the appellant's hearing did not do more apart from the query issued to the manager. There is no evidence before this court that the appellant at the time demanded that the respondent return the said money paid to him pursuant to Exhibit C6A as they reasonably should have done, if actually the appellant was not running the company with Exhibit C6A. The query issued to its manager the query issued to his manager by the appellant, in my view, is an afterthought and a small screen to cover the tracks that would make the appellant liable to pay the respondent his gratuity. Sorry, that will make the appellant liable to pay the respondent his gratuity. Therefore, by the circumstances surrounding C6A, which is before this court, and the inability of the appellant to deny its authenticity, I hope that Exhibit C6A, though unsigned and undated, is admissible of the issue in favor of the respondents. Issue 2, which is whether the email in Exhibit C6A relied upon by the learned trial judge to award gratuity in favor of the respondent is capable of creating a valid contract binding on the appellant. I have summarized the arguments both counsel on this issue, and in determining it, I said it is my view, and I so hold that Exhibit C6A is a valid contract. So I resolve this issue in favor of the respondents. On issue 3, the trial judge can assume jurisdiction to compel the appellant to pay gratuity to the respondent that was not founded on the contract parties. And resolution, I came to the conclusion Exhibit C6A and Section 254, Section 1K of the National Industrial Court, that's the trial court, has jurisdiction to entertain the subject matter and to compel the appellant to pay the response. It should pay in favor of the respondents. On issue 4, I've also summarized the arguments of both counsel, and in resolution, I said fair hearing is the cardinal principle of justice, which demands that a party must be heard before the case against him is determined. It is a fundamental principle. I've given authorities to that effect. A party has a choice in the mode and manner of conducting its defense in a suit. What is paramount is that the trial court must have afforded all parties the equal opportunity to present or defend their cases. Therefore, if a party had an opportunity of being heard but did not utilize it, it cannot bring an action for breach of fair hearing. I've given authorities to that effect. I have carefully perused the record of appeal before me, including the record of proceedings of the trial and including the record of proceedings. The trial court afforded both parties equal opportunity to prove their cases. Therefore, I see no breach of fair hearing as the appellant was afforded the opportunity to present his case. Again, on Exhibit C6A, I make haste to say that the same is not an extrinsic document to the relationship between the parties, as the referred exhibit forms the bedrock of the contract that bound the appellant and the respondent. Accordingly, the trial court's reliance on Exhibit C6A to arrive at a decision cannot in any way be deemed a denial of the appellant's right to fair hearing. I hold that there was no breach of fair hearing. I resolve this issue in favor of the respondent. All the issues formulated for determination of the appeal by the appellant having been resolved against the appellant, consequentially, this appeal is devoid of merit and it is accordingly dismissed. The judgment of the National Industrial Court of Nigeria, sitting in Abuja, delivered on 10th October 2018, in suit number NICN/ABJ/212/2016, is hereby affirmed. Parties to this appeal shall bear their respective costs. Before now, Honorable Justice Ajume read this judgment and this of the agreement that this appeal lacks merit, he also dismisses it. And he abides by the order as to cost. Also, Honorable Justice E.O. Williams Daudi has read before now the judgment just delivered. She adopts the decision as the decision and abides by the order made hearing. This is the judgment of this court.
As the court pleases.
We thank my Lord for the same judgment. May the Lord continue to strengthen my Lord and protect her as he delivers justice to the God. I'm most surprised.
Thank you.
Thank you.
My Lord, we express our gratitude for the Honorable Court. Thank you.
Well, thank you for your presence and for staying back to take the judgment. That should be all of the proceedings. Registrar, call the
Call.